Digital desk. We're going to be taking you to the courtroom in Geauga County. This is sentencing day for a young man just 18 years of age at the time. This was last April. He was a student at West Geauga High School. You might remember this. It started in the morning as school was beginning. A young man in the bathroom found a bullet. That young man absolutely did the right thing, and he went to the school resource officer and gave that bullet from a gun to the school resource officer. They started investigating. There it was around 8 o'clock in the morning. They looked at security video to see which young men from that high school had been in the bathroom that morning. They systematically, over the next hour and a half, started interviewing one by one the individuals that were in that bathroom. When they got to that man there, Brandon Morissette, it had been about an hour and a half later. He had been to at least 2 classes. Not only did they find a gun in his backpack, a loaded gun, once he was interviewed, according to the police chief there, he admitted that he had a plan and that he was going to, quote, cause harm to students at the high school, and he was planning on using that gun. Brandon Morissette has since pleaded guilty to charges of attempted murder and illegal possession of a weapon in a school zone. Let's take you now to the sentencing of Brandon Morissette for that gun in West Geauga High School last April. Dan DeRose with 19 as we wait for potentially the judge to come into the courtroom. We should be getting underway. Again, this was a really strange circumstance. There were some parents at West Geauga that really got upset after they found out that this young man had been in that high school for about an hour and a half with the gun in his backpack as they went one by one to interview the students who had been in that bathroom. So there had been an opportunity there. When he was contacted by the school resource officer, when it was his turn to be interviewed for being in that bathroom, well, they found the gun there. And again, according to the police chief, he admitted that he had a plan and he did want to cause harm and use that gun in the high school. Whether he was going to use it that day, what he was waiting for, that's a parent's worst nightmare when you think about school shootings and the fact that the gun had been there the entire time, hour and a half into the school period at least. I believe he had been to at least 2 classes, if not a 3rd class, when he was finally interviewed and questioned by the authorities at that school. I'll tell you what, in fact, we do get the IRY, so we'll stick here with the sentencing for Brandon Morissette.
It's Wednesday, May 15th, 2024. I'm Judge Paschke. We're on the record on case number 23C70, matter known as State of Ohio versus Brandon M. Morissette. Mr. Morissette's present in the courtroom today. He's represented by Attorney Henry Hilo.
Good morning, Your Honor.
Good morning. Mr. Flays, the Geauga County Prosecutor, is present in the courtroom, as well as Assistant Geauga County Prosecutor Nicholas Burling. We also have Ms. Walker from the court's probation department with us via video. Mr. Flays, will you introduce the case, please?
Thank you, Your Honor. The defendant was indicted by the Geauga County Grand Jury in a 3-count indictment with specifications on May 2nd, 2023. And after much conversation with defense counsel and the exchange of discovery, the defendant changed his plea on March 21st of this year. He pled guilty to attempted murder, a felony of the 1st degree, and illegal possession of a deadly weapon in a school safety zone, a felony of the 5th degree. The court accepted that plea, set the matter for sentencing. There's been a pre-sentence report completed, and we are here for sentencing. Thank you.
Thank you. Mr. Hilo, do you or your client have any reason why this matter should not proceed to sentencing?
No, Your Honor, we're ready to proceed.
And have you had an opportunity to review the pre-sentence investigation?
I have, Your Honor, both today, the pre-sentence report, and prior to today, preparation for sentencing today with my client.
All right, and do you or your client have any corrections or modifications or amendments you'd like to make to the pre-sentence investigation?
No, Your Honor.
All right, then you can present what you have to present regarding sentencing.
Thank you, Your Honor. Do you want me to proceed now?
Yes.
Your Honor, before I would start, on behalf of my client, I respectfully request my client's father be allowed to address this court.
I will permit that. Would you like to do that now?
I would like to do that.
Good morning, Your Honor.
Good morning.
Sorry if I stumble through.
Okay, take your time.
My son is a loving, respectful young man who took all his emotions and bottled them inside for over a period of years in order. Oh, okay, just take your time. Take your time.
One sentence at a time.
Period of years in order to help me and his mother. His mother was diagnosed with terminal cancer in 2019. At the time, we tried to keep how bad the cancer was from him. He still had the support of his friends and family until 2020 when COVID hit. I was one of the lucky ones who still was able to work in healthcare, but that meant I had to quarantine every day after work due to her condition. This left Brandon to take care of his mother the best he could, with me shouting instructions through the basement door. Brandon became isolated from his friends and family. Once some of the COVID regulations started to lift, his mother started to decline faster. Brandon watched his mother pass away slowly from home. He then turned to me to help me with my grief, never once asking for my help. When I visited him at the hospital after the incident, he greeted me with open arms, which were covered with over 50 knife wounds from him trying to bury his pain. When I asked him why he did what he did, he responded with, "I don't want to die in the same house as Mom." Nor for you to find my body. I still believe the reason he left that bullet in the bathroom was for someone to call the police and he could die by suicide by cop. This is not an excuse for his actions, but meant for the court to understand that he's a loving and respectful young man who still has hopes and dreams to have a positive impact on society. Thank you.
Your Honor, thank you. Your Honor, before I proceed, I just for the thorough report that was done here. I appreciate the time the court and the prosecutor's office have allowed us to resolve this matter. Your Honor, to articulate what took place that day, one has to look at the pre-sentence report and the surrounding facts. Things don't happen in a vacuum. There's always something that leads up to something. And to stand before this court and say that the fear and the disbelief that took place in that school that day, especially in the community that has experienced this before, we understand that pain that it causes. But we have to look at it also as through Brandon here. His father touched on how we got to this point. And the sad point as to how we got here, no one could recognize it at the time. I have a young man who was self-mutilating. Nobody noticed it. I have a young man that was caring for his mother who was terminally ill with cancer. And when all the energies were directed towards taking care of his mother, father and family still had attention on Brandon, but Brandon bottled up everything inside. When you look at the report and you read what took place, and what was happening at the time this was going on, his family did take efforts when they noticed that there was a severe depression, especially after the mother died. He was prescribed Prozac, but he didn't like the way that made him feel. But he still had that Prozac, and on the date of this, when this all took place, during the night, he had made the decision that night before, in early morning hours, that he was going to take his own life. And he has been consistent on this, Your Honor, from the time, even when he talked to the police, the time I've met with him and with his father. He changed his mind because he didn't want his father to find him dead in the same house where his mother died. And that's when he found this gun that was in the house. And I think it's important to note, Your Honor, at least when the officers were upon him, that gun was unloaded. There were loaded magazines. There's no denying that. We're not here to change the facts. But he went to the school that day with the intent of taking his own life. And in discussions with Brandon, what changed was when he got there, this was the end of the school year. You know, graduation, everything's coming up. A couple kids came up to him and he realized he did have friends and he did have a purpose. And I think it's significant to note, Your Honor, he left the bullet. He put the bullet on the toilet with the specific intent understanding that he wanted someone to find him. And when they found him, he cooperated completely. Your Honor, it's really significant also to note that he cooperated with the authorities. Mind you, he was still under the influence of the medications that he had self-prescribing to himself, and also to the emotions of what took place. But he was totally honest about what's going on. I know that there's, and we'll hear from the state, and they've been very direct and forthcoming with everything. There were videos that he was going into videography. But the substance of everything was, when he looked at other people that had gone through this, how they were lonely or whatever went on or whatever took place in their life, when he wanted to kill himself, he wanted to do it in a place where he felt other people that had been cruel to him could at least feel some pain for what he did. But he did have one cognitive moment that allows him still to be here today. Your Honor, I've been coaching and doing things for the years with kids, and when you talk to a parent when their son or daughter tears an ACL or breaks a bone, and the parents feel devastated, their son's career or daughter's career might be in jeopardy. But one thing about that type of medical attention, you go to a professional, you can watch the recovery, and you can see that someone fully recovers. When you are keeping these demons inside you, and those closest to you don't even recognize them, that's sad. And this, as tragic and as fearful as that day was, I shudder to think what the future might have been that day, as does everybody else, as does Brandon. Your Honor, since the court has overseen everything while he's been in the custody since April of last year, he's been involved in the programs there. He's 25 pounds heavier. He's medicated now. He thinks clearly now. He has no thoughts of hurting himself and or hurting others. And I think what's also significant, Your Honor, throughout all of this, he has never once offered an excuse or an explanation to say, well, it's really not that big a deal. He has done just the opposite. He knows what he's caused to other people. He knows the hurt he's caused his family. He knows the fear and hurt he's caused to this community. And he only knows that the only way he can prove it is by a life going forward that ultimately is returned to him, that he could be a solid member of the community. Your Honor, on his own, he wrote a statement, and he'd like to also address the court with your permission. And if we could do so right now. Thank you, Your Honor. Take your time.
I would like to start off by saying that I am truly and sincerely sorry for my actions. I did not mean to scare you all, and I am sorry for that. I also did not intend to cause any harm to anyone whatsoever. I only had the intention of harming myself. However, I do take full responsibility in my actions. And what I did was not right at all. At the time, I wasn't right mentally, and I was going through a lot. I was still having trouble processing my mother's death from cancer in 2020. I have always had mental health issues when it comes to depression and anxiety. I was bullied when I was in middle school, and I've always had self-esteem issues. Many times I've thought about suicide, and some of those times I've tried. I'm not telling you these issues about my life to make excuses, but in the hopes that you can know me better and why I felt the way I did. In no way, shape, or form am I the same person as I was before. I am now doing everything in my power to be a different person. I am taking classes like RU and Climb to better my mental health. I would like to continue to better my mental health when I am in the real world. I do not want to go back to the old person I was. I want to better myself and accomplish my goals. Have a family, and hopefully maybe even join the military. I am not a bad person. All my life, I've been good. I've never gotten into trouble with the law or have gotten into any fights. I am a kind and helpful person and truly care for others. I just wish you were all able to know me as a better person and not the one I was during the dark time I went through. Please have mercy on me and please forgive me for what I've done. I promise if you give me a second chance, I will do whatever it takes to turn my life around. Thank you for your time.
Your Honor, the only thing I would echo is with the pre-sentence report that he has no background of any other criminal activity. And I respect this honorable court, and I know the court will take all into consideration for the purpose of sentencing. And again, I want to thank the court, thank the prosecutor's office for helping us be able to resolve this matter and help the community here. Thank you.
Mr. Flays.
This certainly is a tragic situation, and the defendant's life has been tragic. His childhood's been tragic, and I agree with Mr. Hilo said there. And usually we're here before this court because something happened, and the challenge here is we're dealing with what could have happened, and the state recognizes there's a lot of mitigation here. Certainly. The state also recognizes that the defendant, while he's been incarcerated for over a year, has done about as well in the jail as one could be expected to do, and has availed himself of many opportunities. But while the defendant's life has been tragic, we're here because he planned to inflict an unspeakable tragedy on our community. And the court needs to recognize that and weigh that heavily when deciding what sort of punishment to inflict. Because I think that we're really on the punishment end here. There's the rehabilitation side is challenging. And there's been multiple psychological evaluations in this case. And I know that the court's looked at all those. We've discussed them. That's one of the main reasons that this case took so long to come to an end. But it's hard to get inside the defendant's head. We can't do that. But I think what we can look at are those psychological reports, and I think what we've decided to do is the state's presentation is just highlight some of the items in the psychodiagnostic report and express our concerns to the court. And again, we don't want to debate what was inside his mind or what could have happened. Let's look at the psychological report and what the psychologist concluded based upon their evidence and all the records. And Mr. Morissette denied he had any motive for the offense other than suicidal ideation. However, according to the video he made and his statements to investigators, Mr. Morissette had a great deal of anger towards those he felt had mistreated, bullied him. He felt like an outsider and that no one liked him. In his videos, Mr. Morissette appears to align himself with the perpetrators of other school shootings, while at the same time looking upon the victims with disdain. In advance of the crime, Mr. Morissette took medications to keep him from backing out of his plan. This behavior indicates knowledge of wrongfulness, as he intended to override any feelings or behaviors that might prevent him from reaching his goal. With regard to planning what the police believe was going to be a mass homicide, Mr. Morissette reportedly engaged in many behaviors that would be indicative of preparation for an attack, otherwise known as warning behaviors. Mr. Morissette indicated he planned a school shooting for several years. Mr. Morissette apparently had a grievance with other students that he felt had bullied him and or did not like him. There is evidence of him having violent ideation. Mr. Morissette researched other school shooters and the circumstances of their crimes. He said he shared similar backgrounds with them, identified with them, and seemed quite fixated on them. He also appeared to be fascinated with violence and interests in violence through video games, websites, and weapons. Mr. Morissette stated he was going to perform the act in the library so that it would have the greatest concentration of students, thereby killing the most people. Mr. Morissette brought a gun, ammunition, and a knife to school, saying he was going to use them during the attack. During this evaluation, Mr. Morissette said he lied to the police during their investigation on multiple occasions, at times denying his actions and at other times admitting them. It should be noted he not only admitted his homicidal thoughts to detectives, but also University Hospital's Geauga Center medical staff. So, again, very difficult to get into the defendant's head, but the best we have is a psychodiagnostic report. And again, there's plenty of mitigation here. I'm certainly focusing on the aggravating factors. But when you look at those aggravating factors, I think you do get into the defendant's head a little bit. And I think but for the actions of a student at the school, school administration, and the school resource officer at the time, but for their actions, it does appear that a tragedy would have occurred. And the court needs to think about the impact that would have had on our community. And even though this was stopped, the impact it still had on our community. I mean, we're all parents here. The idea of getting a call that the school's on lockdown and it's surrounded by law enforcement and that someone brought a gun to school and you can't contact your kid, you got to somehow pick up your kid, they're having a staging area. This had an untold impact on our community, even though the defendant's plan was ultimately thwarted by law enforcement. So, based upon those issues, and still in taking account into the mitigation, the state is recommending a definite prison term of 8 years, that would be 12 years indefinite, and waive the fine, and obviously give credit for the 399 days that the defendant has served. And forfeiture of the firearm that was utilized in the offense. Thank you.
All right, thank you. The court has reviewed the pre-sentence investigation. I reviewed a letter provided by Mr. Hilo from Mr. Morissette's father, which was quite similar to his statement made here in court today, and I believe that was provided to the state. The court has also reviewed the plea agreement. I've listened to the statements that have been made here in court today, and I have reviewed the entire record in the case. I've considered the purposes and principles of felony sentencing under Revised Code 2929.11, as well as the seriousness and recidivism factors under Revised Code 2929.12, including the seriousness of Mr. Morissette's conduct, the factors which make his conduct more serious, as well as factors which would make his conduct less serious. As far as factors which indicate conduct more serious, I do find that factors 1 and 2 discuss the injury and the physical, psychological, or harm to the victims, and I do find there was harm to the community, to the students, to their families, to the staff, to a number of people. I do find that there was psychological harm that occurred. The other factors, 3 through 9, I find do not apply in this case. Factors indicating conduct less serious under Revised Code 2929.12c, I don't find that any of those factors apply. Factors indicating defendant likely to commit future crimes under Revised Code 2929.12d, I don't find that any of those factors apply. Factors indicating defendant not likely to commit future crimes under Revised Code 2929.12e, I do find that prior to committing the offense, Mr. Morissette had not been adjudicated a delinquent child, factor 1. I do find factor 2 applies, that prior to committing the offense, the offender had not been convicted of or pleaded guilty to a criminal offense. And I find that factor 3 applies, prior to committing the offense, the offender had led a law-abiding life for a significant number of years. So taking all of those into account, as well as the other things that we've taken into account, Mr. Morissette, I heard your statement that you made here in court today, and I read the statement that you submitted to the court prior to today's hearing. I read the letter of support from your dad, and I heard what your dad had to say here today, as well as your attorney. I understand that you were depressed, and I understand that you were in a horrible place after losing your mom. I'm not unsympathetic to the situation you were in, and I believe and understand that you were in a really bad place. But we did have, as Mr. Flays pointed out, 2 evaluations from 2 psychologists who said that you knew the wrongfulness of your actions. This was not a snap, spur-of-the-moment decision. The evidence demonstrates that you had a plan. You've pled guilty to attempted murder. Mr. Flays referenced the videos on your phone, both the ones that you made and the ones that you watched. You also packed a gun and 3 fully loaded magazines in your backpack and took them to school with you. And regardless of whether we believe the version that you were going to just hurt yourself or whether we believe the version that you planned a shooting, it's clear that you did have the intent to use that gun in the school. Once again, based on what was found in the videos on your phone, based on the fact that you took 3 fully loaded magazines, the evidence does show that you planned to carry out a school shooting. You may have wavered back and forth, but at least that was a plan. Now, we know that no one was physically hurt by your actions that day, but we can't say that nobody was hurt. The entire community was terrorized. When that shelter in place occurred, it was terrifying for the students, it was terrifying for the faculty and staff, it was terrifying for their parents and families. And some of the responding officers that responded that day were some of the same ones that had to respond at Chardon High School. You can't say no harm was done to them. Your conduct in establishing this plan and taking action to carry it out has to be taken seriously, and the sentence has to reflect the seriousness of that matter. For that reason, I find that the state's recommendation is appropriate. As to count 1, I sentence you to a term of prison of 8 years in prison. Due to the Reagan-Tokes law, then there would be an additional possible 4 years that would be at the discretion of the Ohio Department of Rehabilitation in the event that that additional time is imposed. You would be entitled to a hearing, so that would be a total possible maximum of 12 years. Counsel, did I explain the Reagan-Tokes law
Yes, Your Honor.
appropriately?
Yes, Your Honor, for the record, we object to Reagan-Tokes, just for the record.
I understand, thank you. All right, I also order forfeiture of the Smith & Wesson 910 handgun. Then as to count 2, I order that you serve 12 months in prison and that be served concurrent with the sentence for count 1. We will give you credit for time served in the amount of 399 days. I am going to, and I guess I'll ask Mr. Flays. Mr. Flays, is the state moving at this time to dismiss the first and second specification to count 1 as well as count 3?
Yes, Your Honor, we are.
Okay. The first and second specifications to count 1 are dismissed, and count 3 is dismissed. Mr. Morissette, I order you to pay the court costs in this case. If you fail to pay any financial penalty or costs, the court may order you to perform up to 40 hours a month of community service until the court is satisfied that you're in compliance with an approved payment schedule. If you perform community service on this basis, your financial penalty or costs will be reduced to the extent of the federal minimum wage. The court isn't ordering any payment plan or community service at this time, but renders judgment against you for the cost for which execution may issue. I will limit the amount taken from your inmate account while you're incarcerated to $5 a month toward that. I also want to go over your appeal rights with you. You have the right to appeal or seek leave to appeal the sentence imposed. If you're unable to pay the cost of an appeal, you have the right to an appeal without payment. If you're unable to obtain counsel for an appeal, counsel will be appointed at no cost to you. If you're unable to pay the cost of documents necessary to an appeal, the documents will be provided to you at no cost. You have the right to have a notice of appeal filed timely on your behalf. All right, I believe that covers everything I needed to cover. Mr. Flays, is there anything else we need to address?
Just the PRC advisement, Your Honor.
Oh, yes. You will be subject to a term of 5 years of post-release control under Revised Code 2967.28. If this period of post-release control is imposed following your release from prison, and if you violate the conditions of that supervision, the parole board may impose a prison term as part of your sentence of up to 1/2 of your stated prison term. If while on post-release control, you're convicted of a new felony offense, in addition to being punished for the underlying conduct, an additional prison term of 1 year or what time remains on your post-release control term may be added as an additional penalty, and that may be added consecutive to any time imposed for the new offense. If you are also instructed that most prison inmates are eligible to earn days of credit against their prison sentences for participation in programs. Said days of credit, if you're eligible to earn them, are not automatically awarded, but must be earned in the manner specified in the statute, which is Revised Code 2929.14 and 2929.19. Mr. Flays.
Your Honor, just one clarification. For this particular offense, it's the post-release control is up to 5 years, but no less than 2 years. So 2 years is not subject to reduction by the parole board.
All right, thank you. Mr. Morissette, do you understand that with Mr. Flays' correction?
Yes, Your Honor.
All right, thank you. Mr. Hylo, do you have anything?
No, Your Honor. Thank you.
Okay, all right, we're adjourned. Thank you.
Thank you, Your Honor.
Dan DeRose with 19 News as we watch Brandon Morissette being taken back into custody, remain in custody, and will be sent off to prison for 8 years for his role. What an interesting insight into everything that happened that day back in April. There were a lot of facts that we didn't know. Was there really a plan? How much planning had there been? According to the police chief at the time, there was, and we heard a little bit more about that today, but we also heard about Brandon Morissette's mental state, and we heard that from his own father. His father up there saying that during COVID, Brandon's mother had been given a terminal diagnosis of cancer. His own father worked in the medical profession, so during COVID, when he came home from work, he could not go in the house. He could not expose his wife, who had cancer, to whatever he had been dealing with at the hospital that day. That means Brandon, who was just middle school or early high school, was taking care of his dying mother. And you heard his father say when he would get home from work, he would have to yell inside the basement door do this for your mother, do this now, and give medical instructions. Ultimately, he watches his mother die during COVID. It sends him into depression. You heard his father say that one day he saw his own son in the hospital with 50 cut marks to his body, that he had tried to commit suicide. He then claims that it was not going to be a mass shooting, that almost he wanted to get caught by leaving that bullet in the bathroom, and that he wanted it to be a suicide by cop there at the school. On the other side of the coin, though, you had the prosecutor say, look, he had made videos talking about carrying out a mass shooting, that he wanted to do it in the library so that there would be more individuals that he could kill in one sitting. He had apparently researched other school shooters, said he had identified with them, made a plan saying that he had been bullied and he was going to take it out on all the kids who had wronged him in the past. The judge heard both of those arguments, the depression argument and the planning argument, ultimately siding with the agreed upon plea and the agreed upon sentence, which was 8 years. You heard the judge talk about 12 years. That's the Reagan-Tokes. If he doesn't behave in prison, they could tack on another 4 years. But as it stands, he's given 8 years in prison for that West Geauga incident that did impact so many parents and so many students that day. We will have a complete wrap-up on this story throughout the day and any of our day's breaking news and weather as we get to our 11 o'clock news a little less than an hour from now on CW 43 and our noon news on Channel 19. Until then, I'm Dan DeRose with 19 News. Have a good afternoon.
19 News is everywhere. Download our CTV apps and follow us on social media @Cleveland 19.